Welcome to the top 12 highlights of Chapter 15. I'm Mr. Rodman, taking you through civil liberties. Let's take it from the top, looking at the difference between civil rights and civil liberties. This chapter focused more on the liberties aspect. In Chapter 16, we'll talk more about civil rights, but let's distinguish between the two. Civil rights is really about equal protection under the law based on a protected class, so whether that's race or gender, disability, national origin, ethnicity. Civil liberties are more individual protections based on your ability to be free to speak or free to bear arms or burn a flag or be free from quartering of troops or whatnot. Those are individual liberties, not necessarily a protected class that's all trying to burn a flag at once. So civil liberties more the protected action, civil rights more the protected class in that nature. Now, selective incorporation, we spent a lot of time talking about this, an important concept that the College Board wants you to know, and that is applying the Bill of Rights to the states, amendment by amendment, case by case. And it's applying that particular piece of the amendment to the states. That's a really important point here because it's selective in that it's picking a particular amendment that is being applicable, and it's applying them through a specific case that has been chosen as a result of this particular amendment being selectively incorporated. Now, we looked at the last two that have been incorporated. The Second Amendment, being one from 2010, McDonald v. Chicago, was the case that basically said you're infringing on the right to bear arms, and that is inviolable because it is a right under the Second Amendment. The latest one was Timms v. Indiana, which basically incorporated the freedom from excessive fines on the Timms v. Indiana case. When there are drug charges and they repossess vehicles and homes and other things, is there an excessive fine above and beyond? And they said there was. They selectively incorporated it, applied it to the state of Indiana and all of the states as a result of that. So selectively incorporating, applying the Bill of Rights to the states. Now let's talk establishment versus free exercise. We see this in the First Amendment. Congress shall make no law respecting an establishment of religion, that wall of separation, if you will, that political scientists talk about, so that government doesn't show a preference for one religion or another. And then also prohibiting the free exercise thereof, the ability of people to freely exercise their religion in the manner that they see fit, including no religion as a result of that. So Establishment Clause, really a strict separation standard that we see here, trying to keep from showing a preference for one or the other. Engel v. Vitale being the case that we see here in terms of, can we lead students in a short non-denominational prayer that may be voluntary? Doesn't matter. It's showing preference for one religion over the other. Let's declare that unconstitutional. So Engel v. Vitale being the important case there. Free exercise then looked at this idea of, can government compel certain beliefs or prohibit people from practicing those beliefs? And the answer is no. And we also saw this with Wisconsin v. Yoder. If they're going to exercise their religion, does it infringe on the ability of mandatory requirements for education? And they said religion comes first. Education, you can find other ways to do it, but religion comes first. And it also begs the question of a no religious test provision that we see in Article 6 of the Constitution. You cannot require a religion or a religious affiliation in order to serve in government. So there is no religious test in that regard. And the founders and framers specifically outlined that in Article 6 to make sure that that did not apply. Now, in the peyote case, the Department of Employment of Oregon v. Smith was the peyote case. And they said, you're exercising your freedom of religion, but that doesn't apply to government entities when you're supposed to be working. You can't say that's a free exercise. So they did show some limits to free exercise in that regard. In the school cases, we see one of the most important ones, Tinker v. Des Moines. Symbolic speech is free speech. It is the freedom of expression that is also outlined here. And it did not cause a substantial disruption. Therefore, Mary Beth Tinker and her brother were able to exercise their rights. Their suspensions were negated, and they were allowed to resume a school. And everyone is still allowed to wear a symbolic freedom of speech as they did. Hazelwood v. Kuhlmeyer is this case of prior review. Do the rules of prior restraint that we saw in the New York Times v. U.S. case, where the Supreme Court ruled that freedom of press is freedom of the press, does that apply to school press? The answer is no. Is there prior review and ability for a school administration to censor a publication? There is. They do have the right to do that because it is a public education entity paid for by government dollars. The government does have the ability to censor or review those materials. Now, in the state of Maryland, we do not have prior review. There is a state statute that actually outlawed that, but in some states they do require prior review towards censorship. A couple of other cases that you don't need to know, but are interesting along these lines of school cases when it comes to these civil liberties. Lee v. Weissman, can clergy give a prayer at a public school graduation? In 1992, Lee v. Weissman said that they could not, that it was a violation of the Establishment Clause, and it was showing preference for one religion over another. Now, Westside Community Schools v. Mergens in 1990 said, can religious groups form as clubs like other clubs? And the answer was yes. Free exercise allowed them to form clubs in that capacity. So we see a couple of other cases here in schools where clergy cannot give a prayer showing an establishment of religion, but school groups can form around religion or religious entities, and that is okay as long as other clubs are allowed to join and form as well. The court has really weighed in on a lot of these school cases. The school prayer, we saw that. Creationism in public schools, that being negated, again, Establishment Clause, concerns of showing one religion over another. We just talked about this case about ministers at graduation showing a preference in the establishment. We don't want that in the Lee v. Weissman. And then also organized prayer at football games. Students may do it on their own time, but if it is before the football game as part of ceremonies, that would not be okay. Now, in the West Virginia v. Barnett case, the school said, "Hey, Pledge of Allegiance. Do they have to say the Pledge of Allegiance?" And the Supreme Court said no. They cannot compel you to do that. That would be a violation of your free speech rights in terms of your free exercise to also exercise the right not to speak and not to say the pledge. And Jehovah's Witnesses don't pledge in that capacity. It was against their religion to do so, and the Supreme Court agreed with them and said you should not have to do that at all. Okay, now we move on to the Fifth Amendment, and there's a lot to unpack in the Fifth Amendment. You know, we've got self-incrimination, we've got double jeopardy, but we also have a civil liberty in the idea of eminent domain. Can the government take your property if they give you just compensation for it? And this is, a reversal of Barron v. Baltimore when they said the Bill of Rights didn't apply to states. The Bill of Rights does apply to states, and this is an example of where they do have the ability to take your property for public use. What about mixed public use? This was the situation with the Kello v. City of New London, Connecticut case, and they said they do. If it's for a public-private partnership or some type of public-private interest, they do have the right to take that. It was very controversial. Many state constitutions actually amended their constitutions within their states to protect private property rights as a result of that case. Now, looking at protected speech, we kind of talked about symbolic speech here, but here's some additional speech to take a look at in terms of Dr. Magleby in this chapter goes into a little more depth about some other First Amendment rights, and are they protected or not protected, or is there some in between? The ones we're talking about here are libel, obscenity, and kind of the fighting words mentality. Let's look at libel first. Can you legally defame a person in writing? And the answer is it is a tough standard to meet, but it has to be false. The case of New York Times v. Sullivan was this: you have to prove actual malice. Can you prove liable for a public official? Very, very hard to do. A very high standard to do that for anybody, let alone a public official. You're in the public domain. You have less rights to privacy in that case than you would in the case of being a private citizen. Now, obscenity, the Miller test, basically the concept the Supreme Court said, I know it when we see it. The idea of the slaps test, is it a serious literary, artistic, political, or scientific value type of work? Or is it patently offensive in terms of the community standard that is set in that particular community, which is different in, downtown Cheyenne, Wyoming versus New York City. So that's where the contemporary community standards are applied to this type of Miller test or this SLAPS test, looking at, is it a serious work? Is it a literary work? Is it artistic in nature? Does it have political value or scientific value? That would not be obscene if any of those were to apply. But otherwise, based on those contemporary community standards, it would be obscene. And the idea of community is that you know it when you see it. Now, fighting words usually not protected here, especially if you're inciting to some type of violence. We talked about that. Hate speech, not protected speech. The hate crime laws that have been passed to protect individuals from this type of speech have actually, showed how freedom of speech working in the opposite direction in terms of freedom of the victims that are being spoken about or spoken against to protect their rights in addition. And so that's kind of how we've seen fighting words or hate speech kind of play out. And then commercial speech, can it be false? Can it be misleading? We've seen a lot of that, especially with fake news and whatnot. Can somebody publish something that isn't accurate? It's a tough line to prove. Can the Federal Trade Commission come after you? They do, and they have. But again, do companies get away with it? Unfortunately, they do. In a lot of cases, they do. Going back to some of the school cases, looking at some of the free exercise aspects. Morse v. Frederick is one of these cases. It was a Bong Hits for Jesus case. It was a sign basically promoting illegal marijuana activity, smoking marijuana. And the administration actually made them take it down and suspended students for doing it. It went to the Supreme Court, and the Supreme Court agreed with the school. They said that they should be able to prohibit some speech, especially if it endorses drug use or illegal activity as a result of it. Now let's shift gears and talk about due process, because this is an important aspect of the 14th Amendment. Just as equal protection is, due process kind of breaks down into two types, and that's procedural and substantive. Procedural due process is the idea that, are they following procedures? Are they following the proper methods by which they're carrying out your rights under the law? And that includes things like, did they get a warrant when they were searching or seizing items in your home? Did they inform you of your rights of self-incrimination, to be free from self-incrimination under the Fifth Amendment? Did they tell you that you're entitled to a trial by a jury of your peers, and that should be a speedy trial? Did they also say that you're entitled to a lawyer under the rights of procedural due process? Did they also tell you that you're free from excessive fines or excessive bail as a result of the rights that you have under procedural due process? All of these are procedural in nature, and the substantive aspect is more an item of fairness. Should juveniles be held to the same standards as adults? Should they be charged as adults? Now, the Supreme Court has ruled that juveniles should be dealt differently, but afforded the same due process rights as adults. So while they may be charged as a minor, the due process rights that they are afforded in the Re-Galt case establish that they should be afforded the same due process rights in terms of their procedural and substantive rights under the law. Looking a little deeper at the Fourth Amendment now, this idea of search and seizure brings up the exclusionary rule, this concept that if they go in, the police go in and are looking for something, and the search warrant doesn't include that something, but they find it, can they arrest you for it? And the answer is no. Now, there are some reasonableness tests to apply here, but the idea and the expectation is that the search warrant should be broad enough to cover anything that they might find that would be prosecutorial. And the Mapp v. Ohio case essentially selectively incorporated this, applying it to the Ohio laws, that you could search the house however you wanted to. You didn't have to have a warrant, and they proved that the Fourth Amendment did apply to states under that control. Now, there is a good faith exception if the evidence being used wasn't obtained legally, but it was in good faith in terms of the police didn't know it was illegal or there was a technical error. This is getting harder and harder to prove in a court to a judge because police officers by now should know the Mapp v. Ohio case, but in some cases some good faith exceptions would apply here. There's another case related to this, and this is the idea of a heat thermal device, thermal imaging device that was used to track down homes that were growing marijuana in their basements by using more of the thermal lighting, the special lighting that would give off an enormous amount of radiation and heat to grow these plants. And so the police actually used it to track down and arrest the Kylos as a result of this and convict them. Supreme Court said you can't do that. You can't use a thermal imaging device. You don't have a warrant on the home. Remember, a man's home is his castle, so to speak, and you would need a warrant in order to do that. You couldn't do that without a warrant. The same thing applies to drug tests in terms of the idea of a suspicionless testing. They've got to they're allowed to do it, but they like it more. Courts like it more when there is some reasonable suspicion as a result of this. But the Supreme Court has upheld the cases in which the law has gone in and had some type of reasonable suspicion for testing, and the court has maintained that. A good example is the random sobriety checks that we see, checkpoints on New Year's Eve or that sort of thing, as well as sports in sporting events. We see this in collegiate and professional sports as well. So do students have the same rights under the Fourth Amendment that adults do? Well, it's a little different when you're on school property. When you're at home, sure, you have the same rights, but when you're on school property, it is government-funded property, and you agree to abide by the terms which are given in order to be on that property. And so they have the right to search your materials, including your locker, your purse, your bag, if they have suspicion of doing so. In the New Jersey TLO case, the idea was, do they have the right to search your purse if they have suspicion to believe that you're carrying something that is illegal or contraband? And the court ruled that they did. They do have if they have a reasonable suspicion or reasonable cause to believe that, they can do so. Let's move on to the Fifth Amendment now. You have the right to remain silent. The Miranda Rights we're all familiar with from those cop shows. But this is from a 1966 case that incorporated the Fifth Amendment and basically said that you do have the right to remain silent. You don't have to speak to the police until an attorney is present. And you do have the freedom to not say anything at all if it's going to self-incriminate or basically work against yourself. That was the Miranda case. By the way, that case was remanded. He ended up did get out and was stabbed in a bar, but he did die, unfortunately, in that stabbing. But the good news is that the assailant, the person who stabbed him, did get their Miranda rights read to them, kind of oddly enough, in an oxymoronic sort of way. We go to the Sixth Amendment now, the right to counsel. This comes from Gideon v. Wainwright. If you have a phone or the internet, you have a lawyer, giddy on up and get yourself a lawyer is what I used to tell students. And the case of Gideon v. Wainwright, the idea that can you afford a lawyer? If you can't, the court will appoint one because you do have a right to a lawyer. And Gideon, if you ever want to watch Gideon's Trumpet, new movie on Netflix or Amazon, that really outlines this case of Gideon basically being unfairly charged and didn't have a right to a lawyer, so he was found guilty. Wrote to the Supreme Court. They granted writ of certiorari to hear his case, and did see that in incorporating the Sixth Amendment to the states, that he had the right to an attorney, and one needed to be appointed to him. And with that, he was found innocent. He was found innocent, and they did end up finding the assailant who was guilty of the bar break-in and stealing from the vending machine, which is what they were charging him with. We move on to our last case, and this is incorporating parts of the Eighth Amendment. We mentioned Timms v. Indiana. This is the cruel and unusual punishment aspect of the Eighth Amendment that was incorporated in 1976. It was a Georgia law that basically was the death penalty, and using the death penalty in this case, the Supreme Court agreed that the death penalty, there are situations that may be cruel and unusual, but this was not one of them. And that the state of Georgia could use the death penalty as a form of punishment, and it was not deemed to be cruel and unusual as a result of that. So that was incorporating the Eighth Amendment in 1976. That's the highlights from Chapter 15. Hope you found this helpful. And if you would like, please share it with friends. Appreciate that. And hope you have a great time living the five, and good luck on the upcoming test and or exam.